You are Michelle Lee Cormier? And Ms. Cormier is charged with the first-degree felony offense of murder in cause number 25 DCCR 0153. Mr. Radford has filed, there's a motion to quash the indictment. The state has filed a reply. Obviously, I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder?
Judge, if I may, the common law has established that murder is when someone intentionally and knowingly causes the death.
Okay, the statute is what we're going to go by.
Yes, ma'am.
Okay.
But I don't think it was the intention of the legislature to remove the requisite mens rea.
What makes you think that?
Because the common law going back 1,000 years has required murder to be intentionally and knowingly.
But they've added section B4, which it's a little confusing because the caption states it's 1902C, but the way it reads is the way B4 reads under 1902, which requires only knowingly, not intentional, knowingly manufactures or delivers a controlled substance included in penalty group 1B, blah, blah, blah. That's fentanyl. That's what the allegation is. And so it actually has the mens rea of knowingly deliver. It reads straight from the statute. So I'm going to deny that motion to quash.
Can I
Sure.
just make a brief argument?
Yeah.
Under this indictment, under the way that it's pled, if a doctor gives a patient fentanyl and that patient dies, then that doctor can be charged with murder even though he did not intentionally or knowingly.
Well, there's an exception. The next C, except as provided, well, where was it? I saw this. It is a defense to the prosecution under section B4, which is our section, that the actor's conduct in manufacturing or delivering was authorized under chapter 481 Health and Safety Code or state or federal law, which I think would be the medical purposes. So there's an exception.
Is it my understanding then, is the court of the opinion that the state must prove that my client knowingly delivered fentanyl to an individual?
That's what the law says, and that's what the indictment says.
I
Then and there knowingly deliver a controlled substance, namely fentanyl, and that Shelby Irvin died as a result of ingesting and inhaling that into her body. So
that it's the opinion of the court that Ms. Cormier must have the requisite knowledge that she was giving her fentanyl?
I think that's.
I think
Go ahead.
what Mr. Radford's trying to do is box the court in here.
I'm not gonna.
My interpretation of the statute is just knowingly deliver a controlled substance. And that controlled substance, if it contains fentanyl, is enough for her to be guilty of this offense. If it contains fentanyl and causes the death of a person, then that gets us to murder.
Well, I think that's going to be another whole question because it's specific that
It says knowingly
deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I don't think I'm not going to make that decision. That's not that's just an element of the offense. So the motion to quash is denied.
Yes, ma'am. I would submit that the statute is unconstitutional as drafted.
Okay. I'm not going to find the statute.
I understand.
I'm going to follow it as written.
Yes, ma'am.
All right. So that's denied. Hold on just a second. Mr. Radford has also filed a motion to reduce the bond. Do you plan on calling your client? Ma'am, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
For the purposes of the hearing, this hearing only, we call Michelle Cormier on the issue of bond reduction. Can you state your name?
Just so you know, once she's under, I don't let anybody go far, but if she's under oath, and I am allowed to take into consideration some of the underlying facts of the case.
Yes, ma'am.
We won't go far, but just don't want you to think that can't go there at all.
Yes, ma'am.
Okay.
I understand. Can you state your name for the record?
Michelle Lee Cormier.
And you are the defendant in this case, is this correct?
Yes, sir.
And your bond is currently set at $500,000, is that correct?
Yes, sir.
Can you afford a $500,000 bond?
Yes, sir.
Do you have assets in your name that you could liquidate to make a bond?
My family does.
Your family
Yes.
can help you? Have you talked to your family about possibly helping you with the bond?
Yes, sir.
And how much, what kind of bond do you think your family can come up with?
100,000 or less.
100.
That's what all of them have told me.
100,000, you think they can make a $100,000 bond? Would it assist your case in the presentation of your defense if you were bonded out and could assist me in working on your case?
Yes, sir.
Where were you born?
I was born in Beaumont, Texas.
Okay, have you lived here how long?
I've been back down in this area since I was 13 years old, so.
So you pretty much lived here your whole life?
Yes, sir.
And you have family in this area?
Yes, sir. Jasper area, my aunt here in Beaumont.
Where would you live if you made bond?
The Golden Triangle, Beaumont, where I'm Spider.
Who would you live with?
My aunt, my 83-year-old aunt that comes and sees me, or my son and his grandma in Spider. My aunt lives here in Beaumont, off of Major Drive.
If the court set conditions of your bond, including a GPS monitor and random drug testing, would you agree with that?
Yes, sir, I sure will.
What is your criminal history? Have you been to TDC before?
Yes, sir, I went for a burglary of habitation back in 2013.
How much time did you serve?
I made my first parole, and I served 2.5 on that 10 because they sent me to safety. And I successfully came off of parole July the 11th of 2023.
That's a witness.
I want to know, I'm trying to I think it's probably in this reply. What was Ms. Cormier in custody for
Or theft, if I'm not mistaken, Judge.
when this happened?
Yes,
Okay.
ma'am.
So the allegations here are that you were in custody for theft.
Can I rephrase that?
No,
Okay.
just
Okay.
answer her
Yes,
question.
ma'am.
In custody, smuggled in some drugs of some type in your vagina that you gave to someone else that the allegation is led to her death that had fentanyl in it. Am I correct?
That's it in a nutshell, Judge.
All right, go ahead, Mr. Coleman.
And you don't disagree with the judge's assessment that you, in fact, smuggled fentanyl into the jail?
I'm going to object to that. I think you said the allegations are what he's trying to do now is bind her into a confession.
I'll move on, Judge.
Thank you.
While you were in jail, did you provide a controlled substance or substances to other fellow inmates?
Again, Judge, I'm going to object that is not relevant at this time.
I'll move on, Judge.
Thank you.
Where did you get those drugs?
I'm going to object at this time, Your Honor, to that.
I think any of those are going to go to her Fifth Amendment right against self-incrimination,
Yes,
Mr.
ma'am. One last
Coleman.
question. When you were arrested on the theft offense back in November of 2024, did you have a pending felony drug case in Orange County? Had you been arrested for methamphetamine possession in Orange County?
Yes, ma'am. Yes, sir.
That's all I have.
What's the status of that case? Do we know?
Still pending as far as I know.
Okay.
I don't think it's been filed. But if it's orange, it could
They're
take-
waiting on
it could take
drugs
years.
testing. Okay, anything else?
No, ma'am.
No, ma'am.
All right, based on the criteria under 17.15, the information that I have, the nature of the offense, I'm going to deny the petition or the request for a reduction in bond. I think $500,000 is adequate based on the nature of all of those matters. All right, anything else then on this case?
No, ma'am.
No, Judge.
Okay, we'll reset it for an announcement.
Thank you. May I be excused?
Yes, thank you.
Judge, for the announcement purposes, I am waiting on a report from my expert, and I anticipate that will be early June.
Okay, we'll just do a normal reset and we'll see where we are at that point. Thank you. You can go back with the bailiff. This hearing will be the truth, the whole truth, and nothing but the truth. Thank you. You can put your hand down. And Ms. Tibbetts, excuse me. In cause number 18-28754, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2018 for the offense of aggravated robbery, a first-degree felony, and that was a 10-year deferred probation. Is that correct? And then in cause number 18-28753, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation October 29th of 2018 for aggravated robbery, a first-degree felony, Again, that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
Each of these motions allege that you probation. Count one in each motion alleges that you committed the offense of burglary of a building March 22nd of 2025 in Jefferson County, Texas. And is that true or not true?
No, ma'am. Not true.
Count two in each case alleges that you provided a urine sample March 18th of 2025 that tested positive for methamphetamines and marijuana. And is that true or not true? True or not true?
True.
Count three in each of the cases alleges that you were at a location other than your residence at 11:15 p.m. March 22nd of 2025. And is that true or not true? I'm sorry?
Not true.
Okay. Count four in each case alleges that you are behind in your court-assessed fees, and it's just a little bit in each case, $29 in one and $37 in the other. Is that true or not true?
Yes, true.
Did you enter your pleas of true in each of the cases to counts 2 and 4 freely and voluntarily? The counts that you pled true to, 2 and 4, did you do that voluntarily?
Yes, ma'am.
And did you plead true to those counts because those two are actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true, find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your cases for a hearing. The state on that date, if they want, can put on evidence with regard to any other allegations, and anything that you think is important for me to know, get that information to Mr. Kimler. He will present it to me on your behalf when we come back. I'll also get probation to do an updated report as well. All right, back with the bailiff.
Your Honor, if I may, this is deferred. I think the court has set bonds in the cases that are relatively high. I believe they're.
Do you want to file a motion for, if I've already had a hearing with another attorney, I don't, unless there's some change of circumstances, I don't, we're not going to do that today for sure. But I would need some change of circumstance if I've already had a hearing.
When the reset was, can we get a speedy reset? Or how long?
You're going to get the same reset on a motion that we get so that everybody can get prepared and so that that updated report can get taken care of.
I'll be out to see you.
And just like that, it ends quietly. No dramatic outburst. No emotional speech. Just a decision, and a reset date. But underneath that silence, there's a lot sitting there. Because the court didn't just deny bond randomly. That decision reflects how serious they believe this situation is. A $500,000 bond, untouched. That tells you everything about how this case is being viewed. Not as a mistake. Not as a gray area. But as something with real weight, real consequences. And potentially, a very long outcome. And the part that lingers the most isn't even the legal arguments. It's that single idea introduced earlier. That someone can be held responsible for a death. Not because they meant it. But because they knew enough, and acted anyway. That's what makes this case uncomfortable. That's what makes it stick. Because it forces you to ask a question that doesn't have an easy answer. At what point does responsibility turn into guilt?